Thank you for joining us at 4th Street Law with our Family Law 101 seminar. We're just going to wait a minute or two just to see if other people jump on. Thank you so much for being here. We will go ahead and get started. Alex Cavin is to the left. I'm Caroline. I am to the right. We are 4th Street Law. 4th Street Law has been in Castle Rock since 2003. This is my 25th year of practicing law. And Alex, you can let them know how long you've been practicing.
Yes, I've been practicing for almost 15 years. I'm licensed in 2 states. So I'm licensed in Nevada as well as Colorado. So I've been practicing for what I like to say is 100 attorney years.
At 4th Street Law, we are a full family service law firm. I am also a child advocacy attorney. So what that means is I am a court-appointed guardian ad litem. I am a child family investigator. I'm a child legal representative. And I am a counsel for youth and dependency and neglect proceedings. We're not touching on it today. If you want to hit us up offline, I'm also very familiar with Title 19, which is our children's code, which is the dependency and neglect proceedings. If you've ever had Department of Human Services or something become involved, that is something we can also help you out with. On the family law side, since I am a court-appointed expert as a child family investigator or child legal representative, these are roles that may happen in the family law process. But we've got Alex, who is a queen litigator and knows all of the things. And then we've got me that I'll be able to put just sort of that child twist on it, also with just how Colorado law has changed, especially recently. We've had big changes that just came up in 2024 that we're going to be talking about today. So it looks like we've got some more people hopping on. I'm not giving names out loud because we are kind of doing this confidential for those who are on this. I'll just let everyone know there's people here. Thank you. We're so excited that you decided to join us. I'm Caroline Cooley. To my left is Alex Cavin. We are 4th Street Law. And why don't we just go ahead and get started? Does that sound good to you, Alex?
Sounds good to me.
Okay, so let's go ahead and talk about dissolution of marriage in Colorado. So the first thing to know is in Colorado, you can have 2 types of marriages. You can have what's more commonly known as a ceremonial marriage, right? Your wedding day, you have a photographer, like you go out, maybe you went to Vegas and you had Elvis do it. I do not know, but you have a ceremonial wedding where you have a marriage license and you are married. The second way that you can be married in Colorado is you can have a common law marriage. A lot of people don't really understand what common law marriage looks like. We're not going to do a deep dive into it. I would just say Colorado has one of the fewest requirements in all of the 50 states on what establishes a common law marriage. The crux of it really is how you present yourself in public, and do friends and family and the public at large view you as married. You present yourselves as married. There's more factors than that. There's a lot more to it, but I just want to let you know, if you have a common law marriage question, feel free to reach out to us. That common law marriage in Colorado, very frequent and very common. So next thing that we're talking about is how to go ahead and file for divorce in Colorado. If you are common law married, no such thing as common law divorce. You do not get to say, well, I guess we're divorced now and move on. If you are common law married, you are legally married. If you were married by ceremony, you are legally married. If you decide to call it quits and 20 years later, you try to get married again, guess what? That's bigamy. You're still married. You never got divorced. All right. So that's the big thing to know, is whether you're common law, whether you're traditional marriage, you absolutely have to go through the divorce process. Okay. In Colorado, divorce is a no-fault state. What does that mean? You do not have to cite cause. All you're required to say is the marriage, whether it's common law or traditional, it is irretrievably broken. You do not need to say why. You do not need to go into your dirty laundry. The courts view a divorce like a partnership. If the partnership is now being dissolved, meaning the 2 partners no longer want to be together, from the court's perspective, they're not going to get into your business and try to tell you why you shouldn't break that partnership. They're going to say, if one of you believes it's broken, it's broken, and we're going to allow that partnership to dissolve. The second thing we need to talk about is Colorado does have a residency requirement before you can file for divorce. So before you file for divorce, you are supposed to be a resident in Colorado for 6 months. However, once you file for divorce, even if you have full agreements and you run to the courthouse with your soon to be ex hand in hand with the paperwork and you file it and you say, we got it. We want you to enter the order. Now you need to wait 91 days. And the reason is because the court wants to make sure that you have met those jurisdictional requirements. And so even though there's a 6-month requirement before you actually live in Colorado, the 90 days after that is what establishes whether or not the court is actually going to grant. So I just want to let you know about that. But if you reach full agreements, you don't even need to call the court. They will have it tickled and they'll automatically sign the paperwork and they'll just send it to you and you're good to go. You don't even need to go to court if you have full agreements, unless you have children. But if you have one attorney involved, you can actually sort of divorce by mail, if you will, or divorce by WebEx, which is you're not required to go in person. What is on a petition? When you file a petition for dissolution of marriage, Colorado, again, because it's a no-fault state, we are only interested in biographical information. Names, dates of birth. You do need to know your social security number and that of your children and of your spouse. They do want to know if you're active duty military because that may be an issue. They're also going to want to know, are there any protection orders? Are there any other cases the court needs to be aware of where orders could impact this case, such as a criminal case, a protection order? Is there Department of Human Services, also known as Child Protective Services, but in Colorado, we call them DHS. We need to alert the court just so they know that that's hanging out there in case there's other issues they need to look at. Once you file for divorce in Colorado, an automatic injunction is put into place where you are not allowed to remove health insurance. You are not allowed to take any health insurance, any car insurance, any insurance of any kind. You can't shut down bank accounts and take all that money and send it over to the Cayman Islands that you were hoping to do. You can't pull it all out and gamble. The temporary injunction is put into effect to preserve the marital estate so the court can take a look at it and make sure that everything in Colorado is equitably divided in your case. The first step is you're going to file your petition and your case information sheet. The second thing is once you file that, the court's going to automatically set an initial status conference. The court sets that automatically. If it doesn't work on your calendar, you can get that rescheduled. If you are pro se, you will automatically be scheduled in front of the family court facilitator. If you have an attorney, you will very likely, depending on your judge and the district, you may be in front of a judicial officer rather than family court facilitator. Once you go ahead and do that initial status conference, you have to take a parenting class if you have children. It's a case management order. The paperwork is there. It tells you what phone numbers to call. And a lot of times you can do them online now. The next thing you'll have to do is do your 16.2 disclosures, which is a sworn financial statement. Alex is going to be getting that to a minute. But after you do that, you are required to go to mediation. Mediation is confidential. And you can do it through the Office of Dispute Resolution, or you can do it with a private mediator, okay? Your mediator will file your certificate of compliance with the court. And then once you have that, you can either schedule for temporary orders if you need interim orders like right now, or you just want that final orders hearing. You may have agreements you don't know, but you just want that hearing set. If you feel like you need information once you've gotten those disclosures of that sworn financial statement, Colorado allows discovery. What does that mean? We can propound questions. You can propound questions, right? You can get bank records, financial data. You can ask questions about parenting. If it was a significant issue, we can even take depositions and a divorce matter, if that would be appropriate in your case. And then the next thing that you would have is your permanent orders hearing. We don't really have trials and family law. We have hearings, even though there's still evidentiary. There is no jury. It's only the judicial officer, but we refer to those as permanent orders hearings. Once you get your hearing results, if you're not happy with the decision, you can talk with an attorney about the appellate process. Appellate work is one of the things that we do here at Fourth Street Law. We actually have 3 really great decisions that we've been able to get in the last 2 years, which we've been really excited about. So we're continuing to make headway in changing family law in Colorado. And so that is, in a nutshell, the family law process.
Thanks, Caroline. So, I'm going to be talking about sort of sworn financial statement / the financial requirements in a divorce. As Caroline mentioned, some of the steps involved in sort of the overview of getting a divorce involve things like going to mediation, showing up at an initial status conference. Typically, when you file a petition for dissolution of marriage, when your financial disclosures are due, it's 42 days from the date that the other party is served. Sometimes that might be before or after your initial status conference. Some of the judges might issue a case management order right away, telling you what the next steps are and when things are due and when your initial status conference is due. But what we do at Fourth Street is we put you ahead of the ball in terms of being ready for those deadlines. And so I would say the financial disclosures, the initial disclosures are a part of the discovery process in terms of getting information from each other. You'll hear a lot of judges say, you're fiduciaries of each other. You owe each other an obligation to be open and honest about your financial circumstances. When you file those disclosures, the first thing you're going to start with is your sworn financial statement. That is a document that essentially says, this is where I work. This is how many hours I work. Here's my expenses. This is how much money I have left over. And these are my assets. So it's essentially like a financial form that gives the court what I like to call a snapshot of your financial circumstances headed into whatever the next step is. I put a lot of emphasis on this because it's a very important document. A lot of attorneys really don't appreciate how important that document is because it's essentially an admission, right? Like it's a sworn statement of you telling the court, hopefully, what is true about how much money you work, where you work, and things of that nature. So that is very important in instances where there's an issue of spousal maintenance. If you have children, if there's going to be child support, it also helps us with sort of developing what your theory of the case is in terms of how to protect certain financial assets, or if there is, let's say, real property, meaning the parties own a home, that will be listed on the sworn financial statement, and it outlines what you think the value of that property is, right? So we use those documents, and particularly myself, when I go into a mediation, I put together a whole package for the mediator before you get to mediation. So we are ahead of the ball. And I think that is something that we really specialize in at Fourth Street, is like making sure that our clients get the value of hiring an attorney, right? Is that we're explaining to you what these forms are. We're telling you ahead of time when these deadlines are. We're explaining to you the importance of why you're filing these documents. So I had a case where it was in El Paso County, and it's one of the judges that's retired, but I had a case where the wife in the case, I represented the father, secretly opened a bank account and gave a debit card to her mother or her best friend and didn't disclose this information on the sworn financial statement. So we did a lot of work through discovery to compel that disclosure. So when we get to court, the court's like, why did you not tell them about this bank account? And the person was very embarrassed because they weren't expecting to getting called out. And it wasn't even a lot of money. But once you lie on the sworn financial statement or you don't give adequate disclosures, that really can impact your credibility and sort of whether or not the court is going to give you what you want. A lot of times I feel like I win cases because the judges, know that I'm going to be prepared, honest, and ready to go when it's time to present this information. And I do that through the sworn financial statement and discovery, right? So aside from, getting you to sign this statement and sort of outlining, hey, judge, here's the pie. What kind of pie is it? How are we going to divide this up? I'm also saying, here are the ancillary documents that support this sworn financial statement. So one of the forms that you can use to make sure that you provide the appropriate documents with your sworn financial statement is document 35.1. It outlines all of the documents that you need to do. It's things like 3 months of bank statements, 3 years of your past tax return, depending on whether you're a W-2 employee or you're 1099. So W-2 income is calculated differently, right? Versus a 1099 who's, someone who's sort of a business owner. They might present things like tax returns, K-1s, profit and loss statements, but how your income is calculated is really just like what you make minus your overhead. Whereas a W-2 employee, their incomes could be a number of different scenarios depending on if they get overtime. Is it mandatory? There are a lot of things that go into that, which is why I always tell people, sure, you could do a divorce on your own. You could try to fill these documents out on your own, but there's a reason that we went to law school and we do this in our sleep. It's because I help you get through that without the stress and trauma of having to call a clerk that you hope had their lunch that day that will tell you how to fill out these forms, because they're not allowed to give you legal advice. So that's why we always say, call 4th Street, call an attorney that knows what they're doing to help you sort of gather this information. That said, once you gather all this information, you're not going to just turn that all into the court, right? So what we would do is clean it all up, make sure that it's accurate, submit it for you, and then you exchange those disclosures with the other party. Here's why this is important. Sometimes you'll say, here's my bank statements, here's my retirement accounts, here's my tax returns. And then I'll go through and look at it and be like, well, what about this bank statement ending in 131? Where's those statements? Right. And I have done that and gone back and said, there is a deficiency here. And then we find out that 131 has $6 million in it, right? That you didn't tell us about. We want half of that 6 million, right? So that's why you're getting an attorney, is because our job is really to underwrite the risk of you sort of proceeding on your own and give you the value of having someone that's going to have your back, that knows how to navigate these difficult legal situations, particularly in family law, which can be very emotionally draining. A lot of people say, I don't want to do this. This is awful. But I think if you do the financials right the first time and are honest with the court, we won't have to issue discovery. We won't have to ask you to produce 3 years of bank statements. We won't ask you to produce, like she said, if you have an account in the Cayman Islands, you've already disclosed that. And we know that you're being honest, and you're less likely to have to go through what is more significant and costly discovery. And I always say, when I'm working on these financials, we give it to you in advance, so you have time to gather the information and you can ask questions. And also, too, your financial situation can change in the middle of a case. So, for example, I had a client that was a W-2 employee, full-time, but he had a weird, he worked for the railroad or something. So his income was already weird. And then he was let go, right? So I had to email opposing counsel and say, hey, my client lost his job. We're going to update our sworn financials. And then when he gets another job, we update them again. So you might go through multiple supplemental disclosures to sort of tell the court, hey, I'm still doing what I'm supposed to be doing. And again, this information that you provide to the court and to opposing party are very crucial to sort of making sure that you're not missing anything and that assets get properly divided. If you have a house, we might need to have somebody evaluate that house. If you have a retirement account, what kind of retirement accounts are they? Will they require what's called a qualified domestic relations order to divide said retirement accounts, right? We won't know that if you are not honest on your sworn financial statement. So again, you can get this form from the court, or we typically will provide you with the form for this sworn financial statement. You can fill it out talking about what your deductions are. If you have kids, are you paying school fees for them? Is there daycare? Are there deductions for insurance? All of those things go into sort of how child support is calculated. And then also, too, the thing about child support that people don't understand is they'll say, well, I'm doing 50-50. We're not paying anybody. And then you got 7 kids. And the judge is like, I have seen this with pro se litigants, meaning litigants who are representing themselves. They'll say, we agree that nobody pays anybody anything. And then the judge is like, well, the recommended support is $700 or $800. You have 7 kids. Are you sure you want to do this? And then they'll look at the form and say, well, they're splitting daycare, or one party is paying for the tuition for one of the kids that's in some fancy school. And so the court is more likely to use its discretion to sort of approve a child support modification and deviation that's in the best interest of the child if you've been honest and open. Whereas if you halfway fill out these forms, they are likely to kick it back. And there are some judges that are notorious for that. They'll say, you didn't do it right, see you later. And you have to start all over. So if you're in a situation where you want to do a 91-day or 92-day divorce, you want to lead with your best foot, and by being open and honest about what are your real expenses, right? If you are making $5,000 a month and then you say, well, I got $10,000 in expenses, that makes the court say, okay, we got to look at this closer. Why are they saying that, right? What kind of assets do they have? All of those things go into, again, not just child support, but how spousal maintenance is allocated. If you're allocated a lot more liquid assets, the court can use its discretion in determining if, when, and how much spousal maintenance you get as well. Judges deny people spousal maintenance for lying. I had a case like that where this woman claimed she wasn't making income, and I went on her Facebook and screenshotted where she was communicating with someone saying, pay me under the table. I said, is this you saying, pay me under the table and not through your bank account? And the judge denied her $1,700 amount in spousal maintenance a month for 7.5 years. My client was very happy. But that's why we say you have to tell the truth. Custody decisions, how they're made. Custody is a huge, huge deal in Colorado, right? So custody is essentially like when you're talking about the allocation of parental responsibilities, one of the issues is custody or parenting time in Colorado, right? So how parenting time is decided, it really just depends on sort of what the parties are doing. If the parties decide that they want to agree to a custody plan, because you have some people, like Carolyn said, you're coming in hand, you already know what you want to do. I want to do a 50-50 schedule. We want to jointly make decisions for the kids and whatever, right? And then you have other cases which kind of go into sort of what we see mostly in Colorado, where you have someone who either is the primary parent who is buying for more of the parenting time because that's what the children are used to, or you have someone that has concerns about the other party's ability to parent. And so there are a lot of ways that you can sort of make those decisions or have the judge make those decisions for you. One of the things that I always tell my clients is, look, you want to be the captain of your fate. You want to be able to say, this is my future. This is what I can live with, as opposed to going in front of the judge, because we don't always know that the judge is going to accurately understand your family dynamics. And so it's always best, I think, for the parties to reach a resolution, but that just isn't always it doesn't always shake out that, right? So, at 4th Street, we really put an emphasis on, if you need aggressive representation, you can come to us to handle that. I like to lead with being reasonable and just sort of saying, how can we settle this? How can we help these people reach whatever their new normal is without a bunch of torturous litigation? But you really have to sort of balance that, because sometimes your clients do require sort of an attorney that's going to empower them, that's really going to push them across the finish line, because they're so exhausted by the time they get through the divorce that they're just like, I can't do it. Right. And I feel like I'm that kind of attorney. I'm very much a cheerleader. I have very good relationships with my clients because I tell them the truth. Right. So when we're going into the courtroom, I'm going to run you through 1410-124, which is the best interest of the child standard. That's what the court's generally looking at when they're deciding these parenting plans. Now, the thing about this is I could have the exact same case in front of 3 different judges and get 6 different outcomes, depending on if they had lunch that day, right? Because different judges, when determining these parenting plans, and if they're in the best interest of the child, can consider different information. So, it's not just about what mom and dad want. It's not about if the kid can offer sort of an opinion as to what they want the parenting time schedule. They're going to look at things like, where are the parties? How far apart are you on speaking terms? Is there any sort of history of domestic violence or substance abuse that needs to be taken into account in terms of fashioning an appropriate parenting plan for that child, right? Are you guys, when you filed this petition, are you acting like adults? Because I can tell you that a lot of these judges really put a lot of emphasis on how the parties treat each other going throughout this process, and whether or not they believe one party or another can prioritize the children's interests, their needs ahead of their own, right? Can you encourage a relationship with the other parent? And if so, is that contact going to be safe? So this is not just like a one size fit all. I know a lot of people say that, like, oh, well, somebody at the bar might say, oh, I got 50-50 because X, Y, and Z. You could have those same facts, but your case might not turn out that way, depending on how you present that information and how the judge interprets the evidence that they're presented with, right? When you're talking about a parenting plan, it depends on if the kid is 16 years old and is driving themselves. They might be saying, I can drive myself back and forth. Whereas someone with younger children might say, we've had drama in the past. I don't really want to interact with this person. I don't want them coming to my house and I don't want to go to their house. Let's meet at the Target on Santa Fe, whatever, right? So it's really what's best for that family in terms of where they do their exchanges, right? Or they might say, we'll do a week on, week off, or we might do what's called a 5-2 or 4-3. And again, this is really meant to just be a general overview, but the major takeaway that you should take from this is that there's probably hundreds of different plans you can outline based on how those factors align for your particular case and what is best for your child. So Again, if the parties agree, you could essentially execute a joint parenting plan. I always recommend that the parties, even if, let's say, hypothetically speaking, you say, well, I don't really want to get an attorney. I know what I'm doing. I want to do this on my own. I always recommend that even in that case where you have two people that are incredibly smart and know what's best for their family, for them to at least have an attorney review it. Because when you just use the forms that are available online, a lot of times I'll see parenting plans that are like impossible to enforce. For example, my client and her husband had a couple of kids and they just agreed 50-50 on everything. That's what their parenting plan said. And so when they started to disagree, there were no terms for me to enforce. So I had to go in to fix something that had they just paid an attorney in the first place, they would not have had to spend the money trying to fix what I like to call illusory terms, terms that are not enforceable. When you're sort of talking about what that parenting plan will look like and how to modify it, theoretically, I mean, it depends on the parties. I've had some parties that say, this is the parenting plan and we will not modify again for a couple of years, or they'll enter into stipulations and ask the court to approve the stipulations that they have. But that really depends on what does your underlying parenting plan look like. There are things that we as attorneys will put in that mitigate the risk of you having to spend thousands of dollars fixing something that could have been done right the first time. That's why we say, let us help you. That's what we're here. That's why we went to school. That's why we have law degrees, is really to come in and make your lives easier and put less emphasis and stress on the court.
So, Colorado in 2024, you already heard Alex referred to it. It is Caden's Law. Caden's Law has completely changed how Colorado is now making allocation of parental responsibilities, APR, fancy word for custody. Colorado loves acronyms. You need to know that about Colorado. In fact, if we have an acronym, we may change it to a new acronym next year. So right now, custody is APR, allocation of parental responsibilities. Because of Caden's Law in Colorado, if there has been domestic violence in a relationship, that can and very will likely impact parenting time, decision making. And when I say parenting time, if you have a child that has witnessed the domestic violence or has been in that home, and that child is of the age that they are resisting and refusing and engaging with the parent, where that has been that more complicated relationship because of the events in the marriage, it is a very big uphill battle now. I can tell you as a child advocacy attorney, this is what we do. There are many family law attorneys in Colorado that are very concerned about Caden's Law and the enforceability of it. And the reason why is because Caden's Law has some criminal elements to it that in order to be able to regain a relationship with your child, if you have been found guilty of child abuse or domestic violence, and when I say found guilty, I don't mean in a criminal court of law. I don't mean you've been arrested. I mean, there's been an allegation and you have had a judicial officer find by preponderance of the evidence, which is 51%, more likely than not having occurred, that now has materially and permanently impacted your relationship with your child until they emancipate. So because of the concerns with the constitutional implications, meaning we have people with criminal implications, even though they've never even been arrested or charged with a crime, they're being labeled as domestic violence abusers and child abusers and things like that in a civil context. It's going up in the appellate. It might be between 2 to 5 years before this gets cleaned out in the court system. And in the meantime, all of your kids are going to be 2 to 5 years older. Okay. So we've got right now 13-year-olds. By the time this gets resolved, they'll likely be emancipated. Now let's talk about what is deep. Okay. Domestic violence is not just physical. It's not like in the olden days where you just slap someone or punch them, or it's a lot more than that. You have what's called coercive control. Is someone following you? Are they controlling your finances? Do they choose when you have your phone? Do they like to track your whereabouts? Do they have a tracker on their car? Do they like to know where your money is being spent? Do you have to ask for permission before you go to the grocery store? That is called coercive control, and that is domestic violence in Colorado. Domestic violence also includes verbal abuse, mental abuse. You hear a lot of people talk about narcissists. The word narcissist, oh my goodness, is that thrown around? A clinical narcissist is not as common as we think it is. But what I can tell you is, do people have narcissistic tendencies? Absolutely. Do they have egocentric tendencies? Absolutely. Do they have when they feel like they're tricked? Do they have to just like lash out and maybe they do it very ugly words and it hurts everyone around them like an exploding volcano? That is verbal and emotional abuse. And so when that happens, that can and very likely will impact your custody arrangements with your children moving forward. So if you're in that situation, if you are the party who is experiencing, if you're the victim, I strongly encourage you to come up with a safety plan, for you to talk to a mental health professional and to go to a domestic violence shelter to get some help. You can also reach out to us. We can help you. If you are someone who may be engaged in some of this bad behavior, the point is, where do you go from here? How do you handle it? Do you take accountability? Do you act like an adult, as Alex said? And we move forward. Are you able to put the interests of your child first so you can regain that relationship? Okay, the second thing that we need to talk about is substance abuse. Substance abuse in Colorado, if there's children, that's really what we're focused on here. If there's substance abuse, that can create an unsafe situation where you may need to file what's called a motion to restrict parenting. And what that means is if your spouse or significant other has gotten a DUI with a child in the car, you need to file a motion to restrict. Okay. If they have been charged with a crime, a violent crime where the child was present, you need to file that motion to restrict. If you heard from the grapevine that maybe this happened or whatever, and you don't really know, and it's a bunch of hearsay, that may be a case where you talk to an attorney. You might need to gauge, is this the point of becoming unsafe behavior? Does it need an intervention? Or do we need to go to the point of filing a motion to restrict? And then the court's going to appoint someone like me, which is a child family investigator or a child legal representative. What is a child family investigator? A child family investigator, a CFI, that is under 1410-116.5 in Colorado. And when I am appointed as a child family investigator, I am an independent arm of the court. What that means is I don't represent mom. I don't represent dad. I don't represent child. I am there because the judge is not going to go to do a home visit. The judge is not going to sift through your laundry. The judge really would prefer not to talk to your children unless it is necessary. Okay. So what I do in that, or someone like me, they talk to you, they talk to the kids, they do home visits, they do school visits. If there's substance abuse issues, you might do substance abuse testing. What's a CLR, a child legal representative? That is an attorney appointed to represent your child's best interests. So what does that mean? Again, when I'm a CLR, I don't really care what mom wants. I don't really care what dad wants. I may not really be interested in what child wants if I feel like child is being unduly influenced. I care what the best interests of the child are and how do we get there in a way that's safe for the child. So those are the big issues. Okay. My question is, if you're filing a divorce on your own and it was just accepted by the court, what's the next step in the process? The next step in the process is the court is going to automatically issue that initial status conference and a case management order. And that ISC date is going to be automatically set. But that case management order is going to list out all the timelines that Alex was referring to, as far as when you have to do your parenting class, when you have to do your financial disclosures, the process to undergo discovery, mediation, permanent orders hearing, temporary orders, all that kind of good stuff. That's outlined in that case management order. Is Colorado a mother state? Thank you very much for asking that. That's actually a really, really great question. Not really. And here's why. Colorado recognizes that parents, mother and fathers, are both presumed under the law. They're both presumed to be equal capable parents. And then that is a presumption that is going to have to be overcome. Now, does that mean there's always going to be 50-50? No, absolutely not. I'm just saying there's that presumption. And now we need to go ahead and establish, why is it in the best interest of the child to spend more time with mom than with dad, or with dad versus with mom? Because again, it's not really a mother state. It's not a father state. It is a best interest of the child state, which is really case and case dependent. All right.
Will a parent who is a child abuse charge be considered to be dangerous to other children, like the stepchildren? It depends. Like if there's something like that with child abuse, or if there's a finding against that person, that can definitely impact whether criminal charge is issued, or if there's some sort of protection order that's issued that precludes them from being around children at all. So really, it just depends on what was the charge, what is the disposition of that charge, how old is the charge. I mean, I've had cases where someone had a child abuse charge because they committed domestic violence against their spouse in front of the child, and they were charged with DV and child abuse. And then the court went on to enter a 50-50 parenting plan later. I've had other cases where the court said, okay, you can still be around these other children again. It's a case by case sort of basis that those things are decided on.
In that case, the court may appoint a CFI or a CLR.
Right.
We have a really great question here, and this is awesome. If the other party is pregnant with another man's baby, but we are not fully divorced, what now happens? Thank you for asking that, because we actually have that case right now. And I've got good news for you. Just be honest. As long as the court knows, because one of the questions the court has to ask you, only to women, are you pregnant? That, like, before they will divorce you, you have to affirm under penalty of perjury you're not pregnant. And again, the reason why is because child support, right? So all you need to do is just disclose that pregnancy. Now, if we're now turning into an issue of, I don't really want it to be any of his business or whatever, we can have that discussion. But it is very important for purposes of child support that we know who the father of child is. Okay? Because we actually have the situation that we have with the case. This often happens. The parties were together, they broke up, they tried to reconcile. During the reconciliation, things happened. They really reconciled, and then it broke apart. But now there is another pregnancy, but now they've decided to go ahead and divorce. Or we break up, we go through the marriage, and now she's in another relationship, and now she has become pregnant. In both situations, we need to talk about that. And the court needs to know. And the court does not need to know because they're shaming. No fault state. This purely has to do with child support, because the court wants to make sure the right person is charged with financial support of the child. If a USA citizen married an immigrant last year, do you still go through the divorce the same way? The answer is yes. Depending on what kind of visa your spouse has, that will impact whether or not they're able to stay in the country, or whether or not they will not be able to maintain their visa. We do work with immigration attorneys, and I happen to know a lot about immigration law. And so we're able to work through those issues with you. But the divorce would be the same way. As far as the immigration implications for the spouse, that will absolutely be a factor. My office is in downtown Castle Rock. I'm over here by Angie's, by the funeral home, by Pegasus, and historic downtown Castle Rock. That's where we are.
I just appreciate everyone, coming out virtually to listen to us. I really hope that you receive some valuable information, and that, if you do have some legal needs, that you think of us, because we really do very good work here, and we really do care about providing quality service to our clients. So that's it for me. I just really appreciate everyone's time today.
I hope y'all have a great night. I hope you guys stay safe. I hope the information we gave maybe gave you a little bit of peace rather than more heartache. If the information we gave you is heartache, call me tomorrow, complain. And we'll see what we can do to make it better for you guys, right? But really, we just want to make the process less scary. I find taxes very scary. That's why I have an accountant. So I can only imagine for people who aren't an attorney, how the divorce process is. We're just here to hold your hand through the process. And I mean, it's going to be okay. You know
Yeah,
what?
exactly.
It's going to be okay. You'll be able to get through it and your kids will be a-okay.
Right.
So I just really want to be able to thank everyone. I'm just sending you love from 4th Street Law to you. And I hope that you guys have a really great night